Good afternoon and welcome into the Senate Government Operations Committee meeting of Friday, February 6, 2026. Two bills up for consideration today. The first is S-298, an act relating to creating the Vermont Voting Rights Act. We're joined today by Legislative Counsel Tim Devlin, who's going to, at about a 30,000-foot view, walk us through the bill. It's a very thick bill with, I think, 25 or 30 pages. So I'll let Jim walk us through it.
Well, thank you very much for having me. Members of the committee.
Yeah. And remember, she sees you if you look here.
Okay, right. I'll keep an eye on that. For the record, my name is Tim Devlin, Legislative Counsel. Indeed, before you have the bill as introduced, that is S-298, the Voting Rights Act of Vermont. And indeed, this is a deep bill. But I can kind of describe it. It's a subject material falling into six main areas. The first would be language assistance for voters. Second would be assistance for voters who are 65 years or older and voters with disabilities. Third would be changes to electoral practices, boundaries, and voting systems, that is, at-large systems, and the process about which to go through those at the local level. And let's see, fourth would be voter outreach funds and a mechanism to support that. And fifth would be a series of new criminal and civil measures, prohibitions on election interference. And then lastly, sixth is addresses the idea of how offenders are counted in the reapportionment process. So we have the reader assistant headings are really just kind of dividing this into two different parts. The first being the Vermont Voting Rights Act, which is 5, 6 of it, and the last part being the counting offenders and reapportionment for legislative districts. So starting in the Vermont Voting Rights Act, Section 1 will create a new chapter in Title 17. That's where all the election provisions are housed. The first subchapter is definitions and rights of voters. I'm going to skip definitions for now and return to them if wanted to provide for any content analysis later on. The other half of the subchapter has to do with essentially broad guarantees on the right of voting. And we see that at the bottom of page 4 and
Section 2.
Yes, correct. So we have voter denial or dilution, essentially brought as preventing those, or guaranteeing a right against those being infringed upon. Then in 2803, apologies, through page 5, we have a prohibition on impairing the rights of voters registered. So we'll turn now to subchapter 2, having to do with the assistance in voting in elections. And here we have provisions getting to a few different categories of individuals who will receive assistance. One is first based on language. So you have a mechanism for determining which languages will kind of be selected for enhanced assistance. And that's a process that goes through the Secretary of State. In selecting those, there's some definitions embedded in there as well. And the findings of the Secretary of State, which are published annually. And then we see the assistance to voters actually having on page 7, where it begins earnestly. And that is where the Secretary and the Constitution municipalities described that are selected by the Secretary actually into assisting those event. Then that review process. We have also, should know, the right of action here in subsection D. That's on the bottom of page 8. And that is where residents who are qualified to vote, and those individuals were aggrieved by a violation of the language services provisions, and bringing action, civil action, Superior Court. And I know I'm breezing through a lot of this, so if anybody wants to stop, just ask me to go down. Happy to. I am very much.
And just, may I provide another section,
Sure.
on section D?
Yeah.
Thanks. Brian. On the right of action, don't we currently have that? I mean, doesn't every citizen have a right to action at the moment on this?
For, I don't think so in this regard, I would say. So right here, we're talking about a new kind of duty that's to be imposed on the Secretary of State to identify certain term years, minority languages, and then basically assist municipalities where they may find themselves short of resources or capabilities in assisting the municipalities in providing assistance in turn to those individuals who may speak with minority languages. And then really, if those municipalities are following through on that, generally the Secretary of State is properly following the process detailed here, individuals who are aggrieved by that say, yeah, I didn't actually receive those assistance, making my life much more difficult to vote, because have greater proficiency in the English language. Then they can bring action really to compel the acceptance. So there's nothing really in my mind in 17, Title 17 that is, that covers the same kind of conduct. Mostly because this is
It's such a basic right. I would have assumed we had free courts always, no matter who you were.
sure. I mean, it depends on the type of voting conduct we're talking about. But here is essentially a new kind of service being provided. And so with it, there, because such a thing doesn't exist today, there's no real anything to go really after that civil action. But other types of infringement on the right to vote, we do have certain criminal provisions here as far as like criminal threatening, stuff like that, that do have kind of an enhancement in for in an election context, but nothing really in this kind of ilk.
Okay, great. Thanks for the delay.
So we're on page 9. Now we turn to assistance for certain voters. Those certain voters are individuals who are 65 years of age or older, and voters who may be physically disabled. And so here we have the assistance taking the form of, let's see, not necessarily having to enter the polling place, but if they are within under 50 feet of the entrance, a poll official can essentially come out and have them vote there and turn the ballot. Let's see if there is, see, B gets into the individual with physical disabilities and who are able to read and write. Senator.
Thank you, Chair Collins. Sorry for coming in late on this. Very interested in this bill. So we did get an email from a woman who represents the GOP down in our area in Ludlow, who had some questions about this section, in particular, like the chain of custody isn't the right word, but like the pathway of if you go, maybe it is the right word. If I see my judiciary friend nodding along, where if someone goes out, gets the ballot, how are they verifying that this person is 65 years or older? You know, do they need a license? You know, how would you know? Mm-hmm. And then on top of that, would that person then be taking it? And my initial reaction to that email was, well, right now we send 2 justices of the peace to people's homes, for example, if they're unable, if, for example, in our town, if we do it every year for a woman who is blind.
Sure.
So I guess I'm wondering, when you look at that language, what would your response be to like how that potentially could be implemented, or suggestions of who potentially would be the right?
Well, I will say that the process is rather silent. So, you know, there's nothing here about voter checklists or just announcing to it. Could that be added? Absolutely. But as far as chain of custody, so that's was one of, okay, who is this person voting?
Yep.
Second, chain of custody, to voter marked printed ballot in the presence of the officer, in a secret manner, during the voter's row, vote, and then return the ballot to the officer, who then in turn immediately returns to the polling place. That's really good.
Okay.
So the ballot doesn't really leave the presence of the officer, but there's only one person, unlike the justice and peace scenario group of two. Again, I mean, this can be modified.
Yeah.
It can be wants.
I think that would just be a flag. I think if potentially we wanted to add language where it's the same process you have when you go to someone's home, for example, like about that might be, but I would ask that we potentially invite the elections official, Sean Sheehan, to come and speak to us about that.
Sure. Let's see. So now turning to some neighborhood assistance for certain voters. Subsection B addresses, let's see, qualified voters who require assistance to vote by reason of physical disability or inability to read or write. And they may request assistance in voting and would may designate officer, election, or a person to assist the voter. And there it is, much process over there. I'll just kind of skip that for right now for expedience's sake. Happy to return to any of this other point. Let's see, and then subsection C, we see if a voter requires assistance in language other than English, does not designate a person to assist them, the same election officer makes an interpreter, which shall first inquire. Yes, and essentially that we see here provision for kind of party preference there, which is absolutely the first one. So that can be kind of replicated by section A if there's a worry about some features of partisans, but we see slightly different process for each of these kind of categories of individuals to be assisted. And then we see D from the next page is where we have the penalty provision. And so a person who willfully violates subsection B or C of this section should be imprisoned not more than 6 months or fined not more than $2,000. And again, this is really geared toward the people who are providing assistance, so just election workers. We're kind of on a hook if there's any skullduggery there. Let's see. Now move to.
And can I just,
Yeah.
on this point, I know that we do have criminal, this is a criminal charge. This is not civil.
Yeah,
Okay, yeah,
and I should just.
Yeah.
Oh, just a note for the committee too, the mens rea or the thought behind the crime. Willfully, that's not typically a term we use in the Vermont statutes annotated. It can be intentionally like that, or the committee can calibrate up or down depending on the level of thought that the individual is going into, whether that be purposefully at the top or negligently. The so, subchapter 3 change to
Question about the willfully language. Tim, would the language we would more typically use in Vermont law be knowingly?
Yes.
it could be or intentionally or there's various rungs going up and down the mens rea ladder. So that's just a policy choice to be made by the committee members.
Thank you.
Yeah, leave some late.
Well, I'm getting blinded, so.
So that also is blinding. How about opening the other one? The other one on the top. Other one on the top. Yeah, perfect. Great.
So this is one of the places in the bill where we kind of change gears a bit. And we move on to
That's the one.
when essentially municipalities are looking to change the mechanics of voting. And we have that term being covered practices. This is here where we turn to our definitions back on page 1 through 5. And covered practice is the second one in there and really means changing election system to an at-large whole way of electing candidates, changes to municipal say election district boundaries within 12 months of an election, And that is further qualified, like whether it reduces by more than 5 percentage points the proportion of the municipality's voting age population is composed of members of a single racial minority. Let's see, any changes to boundaries of election districts for us in general. Any changes that were restricted the ability of a person to provide interpretive services or materials in any other language for the assistance of voting. Any efforts or choices to consolidate or relocate polling places. Let's see. And then that's largely it. So when a municipality is considering doing one of those things I just listed out, there are essentially 2 routes that can be taken for this can be enacted. So this section 2822, that is covered practices actions required prior to enactment registration. The 2 routes being they can either have involve a notice and review period, or they can go to the Attorney General for a certification of no objection, and kind of cut through some of those time constraints and kind of get the Vermont or stamp of approval from 105.
So Tim, I can't remember if we allowed in this bill for a natural disaster to, because some, when we had flooding or something that would mean we couldn't vote in that place or in that. So do we allow for natural disasters to affect? I can't remember completely.
I would have to re-examine some of the details here. I think there was something in there.
Anyway, it's a flag for as we go forward. Sure. To have in case things happen.
I believe there is some sort of extra circumstance for that thing, but apologies, I'll get it.
That's okay.
Sorts of.
I'm a big bill.
So we'll start off first with that kind of first route. That is the notice and review. So first,
So are we on to page 14 with notice requirement?
oh, sorry, we're on page 11 right now.
Okay, you're still on. Okay.
Yes. So municipality will have to want to make a change in any of those covered practices. They would have to provide 45 days notice. And comment. And then they can revise any proposed changes based on feedback from the public. And then they renotice for an additional 30 days before they're going to take effect. And here again, now let's see, under B2 at the top of page 3, there is a private right of action for injunctive relief. If individuals who are subject to or affected by the covered practice being challenged in Superior Court, and then I should say, there's actually limited reasons they could be challenging. One is covered practice has purpose or effect of denying or abridging the right to vote on the basis of race or color, membership in a language minority group. Or second, if the covered practice as it results in the retrogression in the position of members of a racial or ethnic group with respect to their effective exercise of the electoral franchise. So,
Thank you. I have, I think 2 questions. One is going back to that 45-day notice period. That I believe aligns with when ballots go out. So is that correct that ballots go out for mail election 45 days before?
that sounds roughly correct. I'd have to go and take a look at it.
Okay. If that is the case, I'd want to put a flag on this because I would imagine we'd want notice before ballots go out, not aligned with when ballots go out. The other question I have around the private right of action, the burden of proof for proving that the action was taken to limit voting based on a protected class would be on the person bringing the right of action, right?
Yes, I'm trying to think if certain kind of groups whose membership would be composed of those individuals could also have standing. It would certainly be at least the individuals. I'd have to think more about. And also, I should also note that on page 11, it created section 2821 states that no change to any local election district, ward, or polling place shall take effect within 60 days preceding any election. So actually bumps that out further than 45 days possibility.
Okay, I heard 45 days in there somewhere, and we don't have to dig into all the fine details right now. I just wanted to double check that piece.
It's in section A1. You're right, it's right there on
Okay.
line 3.
So let's see. Okay, now for the second round, which the municipality can implement a covered practice. So in lieu of those other kind of notice and renoticing revision provisions in A and B, in C, we have municipalities are enabled to go.
Hey, are we at page 13?
Yes, page 13 at the bottom, apologies. Let's see, so the municipality may submit a proposed covered practice to the Office of the Attorney General for issuance of a certification of no objection. Again, that's defined in the first pages of here. And really what's important to note here is that they can summarily agree or deny it, but they do have, after 60 days, a default to approval. So kind of incentivizes the AG to act quick. Then we'll move on to notice requirements, additional notice requirements, and there's requirement to publish in newspapers that general circulation in the area where the changes to be made, as well as a requirement for mailers to go to registered voters who are in the districts that are being affected. Those are supposed to go at least 15 days prior to the general special primary election. So this is best understood as those changes have been essentially approved and are going to be taking effect. These are secondary kind of reminders to the voter before they actually are expected to vote that, hey, there's a change.
You're going somewhere else.
Exactly.
Can I just, page 15, lines 4 through 7,
Yes.
it would be up to the Secretary of State to cover the costs of creating a GIS map.
Let's see. So here for context, municipalities are to send GIS maps to the Secretary of State's detailing the boundaries of any change in wards or districts. And the municipality does not, any municipality does not have such capabilities, can request the Secretary of State's office to do that on their behalf. And so presuming that the municipality doesn't have the capability, and Secretary of State do it on their behalf, they would, in that instance, yes, cover the cost of that. So now we move on to the sub chapter 4. We're halfway through page 15. This is the at-large method of elections. So section 2831, at-large method of elections, limitations, violations, remedies. So in essence, what we have here is kind of a general prohibition on changing to at-large method of elections. And here, I should say that includes one that combines an at-large election with districts with ward-based elections. So kind of a hybrid method, not just strictly at-large. And again, they're not to be imposed or applied in any manner that impairs the ability of members of a protected class or to elect candidates of its choice or its ability to influence the outcome of the election as a result of the dilution or abridgment of voters, rights of voters, or members of that protected class. So I shouldn't say it's a prohibition. I mean, correct myself there. It's fair to characterize that it's prohibited if it impacts detrimentally certain protected classes of voters.
And who would determine whether that is an impact on someone? And then I see Senator Bielski with quick question too.
Sure. Let me see. Actually, charge anybody that be left at the court. I presume that would be left to the municipality to judge that they are adhering to the letter of the law. And then if they stray from that, we'll see in the next page, in page 16, any voter who is a member of the protected class and who resides in the municipality where a violation of the section is alleged, can initiate a cause of action, Superior Court. And then the court may, in its discretion, allow for a private plaintiff, reasonable attorney's fees, and party, and then the court shall implement appropriate remedies that are tailored to the violation. So, say who determines it would be to the best judgment of the municipality and then to be correct.
Complaint driven, it sounds like.
Yes.
Yeah. Senator Biegalski.
My question was very similar, and it was about sort of who has the duty to prove that someone was harmed or who had, so really just thinking about, are we once again asking someone to have the money for legal fees, be able to sue, and having a completely complaint-driven system that you then have the burden of proof to say I was discriminated against?
And let's see here, I should state that a little bit more thought, I believe that this is one of the categories of covered practice. So, let's see. So if you're adjusting boundaries, which certainly could happen in moving to an at-large voting system, or there we are, A at the top of page 3, any change to a method of election by adding seats elected at large, by conferring one or more seats elected from single member district to one or more at-large sections. So this would have to go through that kind of pre-approval process. So municipality is doing this. They would again either have to go through the involved notice and revision and renoticing, or go to the Attorney General's office for that certificate of no objection. So I shouldn't say that we're just let the courts do it, although the courts are certainly a backstop here. They would be under the intention of either the public or the Attorney General. That I'm speaking. And this, I apologize, Senator Mahosky, does that at all address your question? I was thinking, I answered my own question there.
I think so, thanks.
So, we have now, I'll just move on to page 16. Halfway through, we have subchapter 5, Voter Education Outreach Fund. This will create in the state treasury a special non-reverting fund to be known as the Voter Education Outreach Fund. And just call the fund throughout the section here. And all payments and charges directed to this fund by chapter 7 later on. And I should just have that. The enforcement and civil action taken by the Attorney General. So violations of this act. Penalties and other funds from public or private sources would be directed to the state. This fund, let's see, ensures provisions as well as direction for the money is found on page 17, starting on line 2. And monies in the fund shall be used solely for the purpose of educating voters and persons qualified to be voters on the rights ensured to them pursuant to federal, the state constitutional, statutory law, and remedies as well. Yes, let's leave it there. Okay, moving on to subchapter 6. This is where we have the election interference provision. So we have 4 new offenses: intimidation of election officers, intimidation of voters, as well as back there, communication of false information to registered voters, and then interference with voting. So, the first one, intimidation of election voters. Any person who, by bribery or intimidation, threatens, any person who, by bribery, intimidation, threats, coercion, or other means of violation of the election laws, willfully, again, there's a that's right, hinders or prevents or attempts to hinder or prevent an election officer at any polling place from holding an election shall be in prison not more than 2 years or fined not more than $2,000. So, yeah, this is for elections. Senator White.
Thank you, Chair Collier. I'm wondering if you could provide some examples of this, because
Okay.
we've certainly had situations where we've had, it's never occurred to them, to my understanding, but there was a rumor that during the 2016 election that we were gonna have poll watchers from this national organization that was, I would say, right wing is the proper terminology for them, however they may not call themselves that. And they never showed up. But they were going to be standing out in front and taking information of people going into the polling place, was kind of the rumor. So then we had another group that came in case they showed up to protest them being there. So the protesters for them did show up, but the people actually who were rumored to be coming didn't. But I guess in either scenario, I mean, could someone who is taking information about someone entering a polling place or recording who's going into a polling place, could that be considered a type of intimidation? Yeah, because what we were told is we couldn't, the reason the protest occurred was because we were told, well, they can't tell them to leave if they showed up and started doing that.
Or taking pictures. I mean,
Or taking pictures. Yeah, we were very concerned.
So, it's an interesting question, and it raises First Amendment concerns surrounding the right to free speech and things like that. And there's, the question here is, okay, where is that line?
Yeah.
When we're talking about political speech, which is very much protected. There's something called true threats in the true threat doctrine. This is a carve out from protected speech. Not all speech is actually protected in the First Amendment, right? So some can be criminalized. So we think of defamation, we think of fraud, we think of obscenity, and true threats are one of those. So typically hear people saying like, you can't shout fire in the theater, something like that. You can't threaten to kill people with certainty. Including strangely kind of nebulous. That's not correct. So the Supreme Court, in a case called Colorado v. Counterman in 2023, looked at this question and really kind of said, okay, what is the mens rea? I'm using that term a lot today. Let's just get in criminal context. What level of mentality thought that the alleged perpetrator, bring to the situation, and that level of thought was said to be, they have to be at very least reckless in how they conduct themselves. So really just knowing that there was a risk that they could cause psychological harm by their harm too. And they just didn't care, and they went ahead and did it anyways. And that would be, the mens rea threshold for having a true threat. So something like waving a gun, it's very reckless. Something like shouting for people's information, that's a little bit harder to tell.
Okay.
But if shouting certain things like death threats or something like that, much clearer. That could be certainly a true threat. But something that may be unseemly, like throw the expletive or using a slur or something like that, that would be protected.
Okay, let's say the group was only taking photos of people of color who were entering the polling place. Is that would that tip it over? Like if they were clearly, or they were taking photos and taking names of people who they believe to be immigrants?
I can't say for certain. These situations are always very fact driven in court cases. And so we have general rules, but then essentially suss out where these lines are on a case by case basis.
Okay.
So maybe.
Okay. Well, I appreciate your legal, you're being a lawyer today. Perhaps.
Exactly. Depends, right? Anyway, but so here we have, again, bribery, intimidation, threats, coercion, or other means of violation of election laws.
But don't we always already have that in our voters' oath?
Voters' oath.
That you
Well,
can.
this is contemplating third parties, not necessarily
All right,
voters themselves.
Yeah.
This could be something that just shows up if it doesn't vote, or, but
You're right, but voters oath is specific to you, you can.
Right, and I should say that there is entire chapter, I think it's 17, maybe 35, it's offenses against the purity of election. And we have about 10 statutory sections on there which get to misconduct by either voters, so things like voter fraud, or election officials themselves, like tampering with checklists and stuff like that. We don't really have anything currently on the books about third parties trying to interfere with elections. I referenced earlier that idea about criminal threat, kind of the closest thing we have. We also have like no guns near the polling places. That's kind of it right now.
And this, I believe this is the response to, because I co-sponsored this bill. This is in part in response to a conversation we had where at the Springfield polling place, there was what I felt to be an extremely intimidating man who was fully dressed in an American flag outfit and then swinging a giant American flag in front of the polling place in a way where he was also shouting things that were for one candidate. Obviously a candidate I was not in support of. But that felt intimidating to me because he had a very large, I mean, we're talking as big as the quilt, waving it around. And I also felt that the lighting was very poor. So it was at nighttime. So I'm just wondering kind of in your, I don't know if that would be considered intimidation, but if he had been yelling specific threats, like don't go in there, you know, don't go vote, that would probably cross the line, but perhaps not the use of the flag as like a waving thing.
Again, it's gonna be fact specific. So is he swinging and missing it? Is he blocking people from getting in physically?
Yeah,
Is he making it very difficult to do so?
yeah,
Yeah, blocking access
yeah.
is
Yeah, they kind of have a, like, you have to go almost through like a gauntlet, which I do think is intimidating as a
I
voter.
think the gauntlet on the whole with all of us there is
I think it
intimidating
is.
for voters. I think the whole Springfield voting spot
Yeah.
needs to be revised, period.
But I guess would this have any onus on the polling place to make changes, to make like better lighting, or like would they have any responsibility on this end
I
to?
think each municipality has the right to implement their own rules with regard to polling places. They can, for instance, in Rutland County, there are some towns where you have to be a specific distance away from the entrance. Some don't allow you to stand there with your lawn sign, some do.
Or some allow you only if you, the candidate,
Are
are
present,
and
you
not
can't stick it in the ground and leave.
We've learned that.
So
Yeah,
I think that may fall in, if he's, whatever the distance is, 40 feet away from the polling door, he can wave it all he wants and he's not violating any polling requirement.
Yeah, and you're right to say there's certain prohibitions on electioneering within certain proximity or inside. There may be, I think I'm not sure exactly how much allowance the statutes give local localities and adjusting those. There may be just difference in enforcement, or something like that. So it looks somewhat different here and there. But anyways, the electioneering provisions are much clearer.
Okay.
So, you know, if the person is wearing a candidate's hat and got within X feet, it's easy to tell.
Yeah, I was told because I was a candidate, I could not use a restroom at a polling place because that could have been considered electioneering.
Sure.
actually, I've
People-
never had that because they always have a place where we are. Yeah, that's.
Not at this particular polling. Booth.
And
I guess I'm not.
Yeah, I know. I was like, okay, fair enough. I'll go somewhere else.
Okay. So next here we have on page 17, the next offense is 2852, intimidation of voters. So we're moving from election officials to voters here. Also there'll be a civil cause of action. Any person who intimidates, threatens, coerces, or attempts to do so. Again, same language as in the other section. Any other person in giving the person's vote or ballot or who intimidates, threatens, or coerces, or attempts to do so. A voter to deter or prevent the voter from voting shall be imprisoned not more than 2 years or not fined not more than $2,000 both. So the operative language there, aside from the kind of conduct intimidating, threatening, coercion, or attempting to do so, would be giving the person's vote or ballot, turning in the vote, or just voting. to prevent the voter from voting, who's voting in general. And I should say we already have on the books, undue influence, for having the voter vote a certain way. Strangely, we don't have preventing voting, but we do have if somebody is either bribing somebody or, coercing them to vote A instead of B or B instead of A. Strangely. So something else. So it's and then there's a private right of action embedded in there too. Next offense on page 18, we have 2853, communication of false information to registered voters. It shall be unlawful for any person to communicate to a registered voter by any means false information, knowing that the same to be false, intended to impede the voter exercise of the voter's right to vote. And then shall apply to information only about the date, time, place of the election. So it narrows itself immediately. And that is an additional carve out for free speech. There's a state interest in a valid governmental interest that the courts have held up in making sure that the logistics of voting goes on without a hitch. So you've probably heard something similar to this in the context of S23.
Yeah,
Yes.
And so the idea of the robocalls where somebody was impersonating by and say, hey, vote this other day.
Yeah.
That's the kind of stuff that's captures right here. Only that was a pretend person, this would still cover that. You know, if you could determine who it is, right? Anyways, so yeah, that date, time, and place, really the mechanics of voting or the registration process as well. So how do you vote and where do you vote? Essentially, no misinformation on those. Then anybody violating that shall be imprisoned not more than 6 months or fined not more than $1,000 for both.
so Tim, can I just make sure I'm understanding, for clarity? Misinformation can include only those categories of where the polling place is, the date, time of the election, or ward.
Time, place, make that kind of idea.
Okay.
Yeah, so if you say that, you know, the candidate has a different hair color, it doesn't matter. Or if you say something like, I mean, it could be more extreme, less silly too, right? But it may fall into one of the other categories, you know, if it's, if you say that.
Your voting doesn't matter. It's
Yeah.
not important. There's nothing important on the ballot, maybe.
That's an opinion. That's
Yeah.
not.
But yeah, that's what I'm saying. That wouldn't count.
I guess, but we've had already 2 big postcards, in our district that are full of false information. What would we do about that?
Oh, you mean related to legislation, but not to
Yes.
polling place.
Senator X said this on issue, you know, it's a lie, it doesn't matter.
Yeah.
This is not gonna prevent that.
Okay.
Free speech and,
Yeah, okay, but this is just about the voting
yeah,
place,
It-
means
when
and
we-
the method.
we're in the conference
Yeah.
committee on 23. I brought up, and you'll see when if it passes the House and gets over to us again, one of the things that we were at one point at odds with the other chamber was whether it was an individual or a political
that's right.
candidate. And the individual example I used was if Taylor Swift came on and said, hey, there's a ballot item in South Burlington about a new pool,
Yeah.
vote no on it. It's a horrible idea. You shouldn't do it. That's not part of S23 because that's not misinformation. If she came on and said, hi, it's Taylor Swift and blah, blah, blah. And by the way, you can vote on this. And she gave a date after the election had already happened. That's misinformation.
And this would include registration too. So if I've heard like scams of, you know, somebody will get a text and be like, you can register to vote by following this link.
Yeah.
And then they're actually not registering to vote to the property. They're just giving private information to some scammer. You know, that would fall into this.
Okay.
Because it really prevents them from
Yeah.
registering to vote. Yeah.
That is such a good. That's such a good one.
So, let's see, then in addition to the code, I'm looking at subsection C here now, if you're 15.
Another go.
Private reduction, yes, exactly. So that's,
Your favorite.
and there's
That's okay.
some differences between these, but the committee wanted to, right now they're essentially just replicated in each sections, but they could be pulled out and then sent to apply to X, Y, Z. And, you know, it's yeah. Fine with us either one. Let's see, and then. Okay, next offense, and this is, it's the last one, fourth, interfering with voting, interference with voting. 2854. Any person acting under the color of law who, contrary to an official policy or procedure, fails to permit or refuses to permit a qualified voter to vote, or who willfully fails or refuses to tabulate, count, or report the vote of a qualified voter, subject to a civil penalty in the amount not more than $1,000 for each affected voter. Then they have to pay that to the fund. And let's see.
What exactly is the color of law?
Sure. So if you're sitting there with a vest that says election official, really anything you're doing is going to appear to a regular person as you're doing it as an official duty.
Okay.
Yeah.
Okay.
Yeah. So it's it may
It's a term of
stray from what your duties actually are, but it's closer to what a regular layperson would think. Oh well, if they say it, you know, it's actually probably follow.
Okay. So it's a term of art.
Yes. Okay. Yeah, thank you. It's kind of undefined duties, or the appearance of undefined duties on the outskirts of official duties.
If I'm wearing my justice of the peace name tag.
Yeah.
That's what we have. We don't have vests. We have name tags that say like JP. That would be when I'd be under this.
Yes. Yeah, so if you take that ballot and be like, I'm not gonna bring this back, you know, that's one of these. Or if you if you're qualified to vote and you're thinking about yourself to.
If I saw them on the checklist, but then told them they weren't on the checklist
Sure.
and told them to go away, that would be.
Yeah, that'd be simple. Okay. And then B1 says any person who furnishes a ballot to a voter or who that person knows cannot understand the language in which the ballot is printed and misinforms the voter as to the contents of the ballot. When they intend to deceive the voter, so there's intent language there, and induce the voter to vote contrary to the voter's desire, shall be imprisoned not more than 6 months or fined not more than $1,000. So this will apply to some of the language assistance. It actually kind of stack, I would say, some of the language assistance provisions earlier. It would apply to both election official who's assisting. It would apply to any private individual who is designated to assist. English individual voting. And yeah, those are probably the two categories people. And so for violating that, let's see, 6 months, not more than 6 months, fine not more than $1,000. And then let's see, we have B2 and 3 as well. Any person who changes a ballot of a voter to prevent the voter voting as the voter's desire shall be in prison not more than 6 months, not fine more than $1,000. Example of that. Okay, primaries would work, right? You give somebody another ballot, or again, language ballot. So it's a little bit rough, which maybe those seems following along. 3, the subject applies to any election, any method used by a political party for selection of its nominees and for selection of delegates to its conventions meetings. Did it work?
So to that last point, if we had that could cover any like Democratic Party meeting. Yeah, we did, because we send folks to the conventions. This would also cover if someone felt that they were inaccurately given information about voting for those candidates going to, like, if we were going for committee man or committee women to the DNC, the Democratic National Convention in Vermont, and that person, this would also cover all of that.
Yeah, actually, I don't know. I'd have to think more about the caucus. So this is to be read with 1 and 2, B1 and 2. So we're talking about furnishing ballots, then so of a different language, or switching out a ballot maybe for a dated ballot
Ah.
or, and primary ballot, but it wouldn't work in that setting. But yeah, something where, it's, yeah, I'm trying to think if it would cover like voice opening or something like
Yeah.
that, because we're talking about ballots. The other two, but I can think a little bit more.
Okay, yeah, because I think it is important that they have equal, we have good regulations related to those types of meetings, but I'm not totally sure how this would play out in reality.
Mhm.
Because usually we have a big meeting and I think they do paper ballots, but I feel like I've done an online ballot too. I don't know if they're allowed to do that.
Yeah, I know that's certain local parties or local primaries.
Yeah.
Digital.
Okay.
So now we move on to subchapter 7. Yes,
So I'm just curious, I think these are all offenses that are worthy of the actions where, an enforcement. Of course, how we get them enforced is always a question. But they're inconsistent penalties, and I think they're all egregious. Why do we have two that are at 1,000, two that are at 2,000?
I can only speculate that, this portion of the bill was based on Virginia's laws.
Okay,
And so those penalties were, I think, brought over.
and these are what are currently in Virginia law?
I believe so. Yep.
Oh. Yeah, well,
I think it was that, yes, I'll double check that.
it just seems odd to me that we are not consistent.
Oh, they can be made to whatever.
Absolutely, I'm just flagging it.
So, enforcement, so we're on page 20 now, and let's see. To be added, section 2861, civil action by Attorney General. And whenever the Attorney General has reasonable cause to believe that the violation of this chapter has occurred, and that the right and the rights of any voter or group of voters have been affected by such violation, they can bring civil action in the Superior Court, the accounting for which collective conduct occurred. Civil action, in such civil action, quote, may award preventative relief, including permanent or temporary injunction, restraining orders, other order against the person responsible for violating. So again, injunctive relief is just, is everybody familiar with those terms?
Mhm.
Okay. And then we get to the civil penalties, we see in B2, and they can be assessed at amounts not more than $5,000 for your first violation, and the amount not more than $25,000 for each subsequent violation. So second, third, fourth, whatever. And those would go into that voter education outreach fund mentioned before. Then there's attorney's fees when the plaintiffs if they win, and let's see, court or jury may award such other relief to a aggrieved person if the court deems appropriate, including compensatory damage, and punitive damages.
So does this subsection supersede the penalties already outlined earlier, the monetary penalties in the section? It seems like we were saying $2,000, $1,000, and now we're saying $5,000 or $25,000.
So they're parallel, although not too far to parallel, likely because there could be a criminal action. Those we just saw those are criminal provisions.
Yeah.
So AG or more likely state's attorneys would go after the criminal, but depending on their faith in evidence, maybe because we have a higher standards there for finding guilt. They may either opt for a civil action instead, or where there's lower thresholds for intervention, or perhaps they let the criminal run the first and then civil action subsequent. That's possible as well, but generally I describe them as the criminal, civil, both actually, and then I guess this would have part of civil, not necessarily monetary damages, but being injunctively baked into it as well. So the Attorney General's office has various tools in the toolbox.
So it would be up to an opinion at the Attorney General's office whether to go along with the monetary guidelines already outlined earlier in the chapter, or to take full advantage of the $5,000 and $25,000.
Or you could have two different parties. The state's attorney could be pursuing the criminal.
And the
Maybe,
AG could be doing the civil.
exactly. AG's office could also be doing it. So,
Okay.
but they'd have to agree amongst them who's gonna bring forward the criminal provisions. Yes. So now we move on to shifting gears to counting offenders and reapportionment of legislative districts. So, just quickly, what these new statutory sections are aiming to accomplish is that if anyone is incarcerated, essentially, at the time of when the Census Bureau is counting individuals in the populace, that instead of counting anybody who's incarcerated in the location of where they are currently incarcerated, it will default to where their last address was, essentially, unless they're serving a life in prison.
Yeah, I was gonna say, some people will be there for the election.
Uh,
And because we do elections every 2 years, you could be in there for 5 years and not a life sentence and still be voting there. So I think this is
well,
the
this is just for
challenge because-
reapportionment, though, as well. So-
I appreciate. We reapportion in, census is taken in the even decade year. And then it takes us a while to draw the lines. But then, once we've counted them, let's say we counted them in 20. Then we're drawing the lines in 21, ready for the election in 22. They may still be in jail. I don't think life in prison is the only sentence at which, I mean, anybody with a sentence of 2 years or more could still be in the same place.
Sure.
If that address was out of state prior to them being incarcerated?
Yeah, what do we do?
Would that put them in jeopardy of being able to vote?
No, it wouldn't, well. I shouldn't say it. So, they, for the purposes of reapportionment in the state, if they have a out of state address was their last address, they wouldn't be counted at all.
Right,
And
out of staters aren't.
only certain states allow, individuals to vote, if you're incarcerated. So if you're a Vermont resident, you can. And we're from the other ones.
Senator Biegalski?
So thinking of someone who lives in the state of Vermont prior to when they are incarcerated, for apportionment, they're counted where they lived. And presumably, if they have to, I don't know, pay property taxes, that's where they lived, not where they're incarcerated. And we allow university students to choose if they will vote where they lived or at the university that they're going to.
Mhm.
So it seems to make sense to me that regardless of where the facility, that they have no choice in where they're sent to, that they would be able to vote where they live.
Yeah, I agree with that.
Yeah, that's an interesting question of whether somebody who was out of state can redeclare the residency to be that of where they're incarcerated, and whether then they could vote in whatever election actually they find themselves in that district. Yeah, I haven't thought about that. I have to think more, and it seems, well, I shouldn't speculate on it.
No, you're.
Danger will run.
But I think you could make the sort of argument in kind of both directions that but that the person incarcerated should get to choose if they're going to vote in the district they are incarcerated in or the district they live in.
Right,
If they can vote in both of those places.
if they're eligible.
That was Tim's other point, is like, you can vote here.
Right.
But if you're incarcerated and you're from another state, but I don't know if do we have any out of state folks being incarcerated in Vermont other than we've moved a few ICE detainees processed through our facilities.
Yes, I believe
but
we have
Yes.
several.
I think so.
we do, so there are folks who
I think so.
are charged with crimes who are
Check with
from the
DOC,
who are
but-
in Vermont.
Yes,
I
I
believe so.
believe so. Interesting. We have some drug offenses for people who are from out of state who are in our prisons.
Well, the other question this raises for me is what about someone who lives in the state of Vermont, thus it has the right to vote, but we are incarcerating in, what is it, Mississippi right now?
Yes, they're voting. They're able to vote, I believe.
I think.
But are they voting in Mississippi elections or are they voting where
Okay.
they came from
I-
in the local election?
We should ask Secretary of State and DOC. We should have those them in. But I believe they get absentee ballots.
So why is that what we're allowing for? So if I am an individual and I live in Essex and I happen to be incarcerated at the women's facility in South Burlington, do I vote in the Essex election or the South Burlington election, or do I have a choice?
I think we should be asking DOC and Secretary of State because they'll have an answer on that.
Okay,
I think there's an answer to that.
I just wanna
Flag.
move things along if you can.
We have some witnesses here. Writing them down.
Let's see, so, would you like me to go into detail on these provisions and see exactly how the mechanics work, or?
I don't think that's necessary.
But yeah, suffice it to say that, when the state is redistricting and looking at, various populations in every census block, they will be taking that information from the census and then taking a look at who's incarcerated at that time of kind of snapshot, and then gathering, there's some information requirements in here from the Department of Corrections and how they're supposed to communicate that to the Legislative Apportionment Board, and that's the legislature itself. And essentially somewhat modifying those numbers to be taken into consideration when those new political districts are drawn. Okay, any questions about this bill? There's a lot.
I have a lot of questions.
Yeah, fair enough.
So
Senator White.
Thank you, Mr. Chair. I just had one note of follow-up, which is I know that we had some potential changes already to this initial draft.
right.
And I'm just wondering how you want to proceed with those with him. You know, if we have specific changes that we'd like to recommend, do you want us to propose them here and then have him draft them? Or is it all right for me to have already, I'm asking for forgiveness after, not permission.
Yeah.
But I already sent him some stuff that would change the bill, I think, in positive.
And the Secretary of State also has some amendments, I believe, to this bill. That we would look at. I assume we would look at all amendments.
Yeah.
Well, I guess I was asking.
I would certainly, in order to speed the process up, you could deal directly with him.
Okay, thank you.
So
Okay.
quickly, we're beginning to get a lot of emails about embedding voter ID.
Correct. I've been getting a lot of them.
Yeah, I have
I'm
to.
not doing that.
I think there's a lot of sentiment about that, but I just want to say it is not in this bill. And at the moment, we are not contemplating that. I just want to say that publicly.
I'm not contemplating it, yeah.
Do we still have witnesses that I had on my list,
We have a bunch
is
here.
it Alana Person, Ben Williams, and Denise Miller?
Marissa Wright, Rose Riley.
No, I think those were,
What happened?
deleted.
Oh.
They couldn't testify today.
Oh, okay. Oh, look.
Okay,
Oh,
so,
there
we're
they are.
scheduled to, go until about 2:25 with this, so if you could each take maybe 5 to 7 minutes apiece. And I don't, it doesn't matter who leads off,
So who do we have? We have,
we're gonna identify them.
yeah, I see a lot of them.
Do you want me to go first? My colleague Ben
Either
from
way.
Partner Organizations
For A.
also here.
Okay,
Your name starts with A, so get it. There you go.
Fabulous. My name is Alana Pearson. First, I just wanted to say good afternoon to the members of the Senate Committee on Government Operations. Thank you so much for the opportunity to testify today on behalf of S0298, an act relating to creating the Vermont Voting Rights Act. I'm the communications lead at Represent Women. Represent Women is a national nonpartisan nonprofit that has spent more than a decade tracking the systems and structural levers that increase women's representation in elected office. We are expressing our support today for the Vermont Voting Rights Act. State voting rights advance Represent Women's mission to increase women's representation in elected office by addressing the systemic barriers that prevent fair participation and representation, particularly for women of color and other historically excluded communities. I want to be very clear at the offset. Represent Women strongly supports the Vermont Voting Rights Act, and we believe that this bill is critical to protecting not just the right to vote, but the right to be meaningfully represented. For nearly 60 years, the Federal Voting Rights Act has served as a cornerstone of representative democracy, ensuring that communities, regardless of race, color, or background, have the fair opportunity to elect candidates who reflect their interests and lived experiences. That promise of fair representation has never been automatic. It has required vigilant enforcement and sustained commitment. Today, those protections face unprecedented challenges, placing increased responsibility on the states to uphold and strengthen voting rights through state-level voting rights acts. These laws are essential to safeguarding against vote dilution and ensuring democratic systems function as intended. Vermont has an opportunity to lead here. From Represent Women's research, one conclusion is unmistakable. Voting rights protections and representation outcomes are deeply interconnected. When safeguards against discrimination, vote dilution, and exclusion are strong, women, particularly women of color and members of language minority communities, are more likely to participate, to run for office, and to win. When those safeguards are weak, the effects ripple outward, narrowing who has access to political power. This bill directly addresses those structural barriers. We support this bill because it takes a comprehensive preventative approach addressing discrimination, vote dilution, transparency, access, and enforcement together rather than in isolation. When we talk about vote dilution at Represent Women, we are not talking about whether people are allowed to cast a ballot. We are talking about whether their votes have a fair opportunity to influence the outcome. And vote dilution occurs when election structures allow people to vote, but consistently prevent certain groups of voters from translating their shared preferences into representation. This can happen in systems like at-large elections or winner-take-all single-seat districts, where a cohesive majority can elect every seat, even when a substantial portion of the community votes together for a different candidate. Over time, those voters may participate fully and still never see themselves reflected in governing bodies, not because of lack of engagement, but because of how systems operate. The Vermont Voting Rights Act is so important because it recognizes that discrimination and vote dilution do not require malicious intent. Even well-intentioned election practices can produce unfair outcomes over time. And that is why we strongly support the bill's clear prohibition on vote denial and dilution and its focus on impact and results rather than intent alone. We also support the bill's limits on at-large election systems when they impair the ability of protected classes to elect candidates of choice, as well as the requirement that remedies be tailored to address the underlying harm. By strengthening protections against vote dilution, establishing a transparent pre-clearance and public notice process for election changes, and preventing last-minute changes to districts or polling places, the Vermont Voting Rights Act ensures that election systems cannot be quietly altered in ways that undermine fair representation. And importantly, this bill does not mandate any specific election system. Instead, it preserves the ability to consider proportional remedies, including multi-member districts paired with ranked choice voting, perhaps, when necessary, to provide proven dilution and discrimination as a remedy. So from our research at Represent Women, these types of remedies are among the most effective at increasing women's representation, particularly for women of color, because they expand opportunity rather than restrict participation, and they allow votes to translate more fairly into seats. In these systems, women are more likely to run, and they are more likely to be recruited, and they are more likely to win and properly represent their communities. The last few things I will say is that this bill also recognizes that representation doesn't stop at casting a ballot. We strongly support the bill's language access provisions, which ensure voting materials and assistance are available where there is a demonstrated need, as well as its protections for older voters, voters with disabilities, and voters facing intimidation or misinformation. These barriers disproportionately affect women, especially caregivers, older women, and women in language minority communities, when participation is limited, women's leadership is the first to be excluded. So these provisions ensure participation is real and not theoretical. So from our full representation perspective, these protections matter enormously. Our research shows that when election systems fairly translate into seats, governing bodies become more reflective of the communities they serve, including greater gender balance and racial diversity. Preventative system level harm remedies, rather than relying solely on litigation after harm has occurred, are amongst the most effective tools we have to strengthen our democracy and advance women's representation. We've seen what's possible when voting rights protections are paired with systems intentionally designed to prevent vote dilution. I'll just note that in Portland, Oregon, for example, reforms implemented as a remedy to have led to the most representative city council in the city's history, with women holding half of the seats and women of color holding seats at elected levels at historic numbers. Out of the 6 women, 4 are women of color. And these outcomes are not accidental. They are the result of intentional design that values representation. So the Voting Rights Act honors the legacy of the Voting Rights Original Act, and it's a legacy that's been built through generations of organizing, sacrificing, and leadership, particularly by Black women, while recognizing that democracy must be actively protected and updated to meet today's challenges, which is what I am very pleased to see Vermont is doing. So at Represent Women, we very much urge you to advance the Vermont Voting Rights Act to ensure that Vermont's democracy remains inclusive, fair, and representative for all, especially women and minorities. I'm happy to answer any questions or send along additional research to back my statements today, but thank you for giving me the time to speak.
Thanks, Alana. We appreciate it.
Thank
Ben
you.
Williams from Fair Vote.
Thank you, Mr. Chairman, and I don't want to get in the way of a Friday afternoon, so I will keep my remarks brief.
We have another bill.
Oh, you have another bill, then I should be extra fast. So so I'm with Fair Vote Action. We are a national organization that supports reforms that improve our elections. We're nonpartisan, and we have many topics that we work on. One of them includes state voting rights acts. Just to give you 4 quick points. First is that as the federal U.S. Supreme Court has taken steps to limit the scope of the Federal Voting Rights Act, states have stepped forward to pass state voting rights acts to ensure that robust protections remain in place for their citizens. This is alluded to in my written testimony, which should be with the committee. Also, the state voting rights acts that have passed in the nation and you're considering right now often have broader protections than the Federal Voting Rights Act. So this is a chance to ensure that Vermont voters have broader protections than they may have had previously while safeguarding against a decline in federal rights. And I think I'll just emphasize that meaningful participation in the political process shouldn't just depend on whether you speak English fluently, shouldn't depend on the color of your skin, shouldn't depend on whether you are elderly and able to enter a polling place. It should depend on whether or not you meet the qualifications to vote set by your state. And the Vermont Voting Rights Act would help ensure that that is the case in Vermont. I will just close by saying I know that there have been some amendments that have been floated around. I would encourage the committee to seriously consider those. And so with that, happy to take any questions.
Okay.
Yeah, could you just tell us the name of the organization again? Fair
Vote.
Fair Vote, right? Okay,
Yes, Senator Clarkson, Fair Vote Action, which is our C4.
great. Thank you.
Of course, thank you. And thank you for the time today.
Sure.
Thank you for thank you for bearing with us.
So our final witness, I hope I'm not mispronouncing your first name. Is it Venice Miller? I know Miller's right.
Yes,
I hope it is.
that's absolutely correct, Venice.
Okay.
Oh, not Nietzsche. Okay, I was sort of hoping it was really.
I answer to it all. Good afternoon, Mr. Chair and members of the committee. Thank you for the opportunity to present to you today. My name is Venice Miller. I'm the manager of outreach at the Election Law Clinic at Harvard Law School. I'm here to testify in support of SB 298 and provide some background on the growing movement to pass state voting rights acts across the country. The Election Law Clinic trains the next generation of election lawyers that will help voters build power. Much of ELC's work centers on state voting rights acts. ELC has written about state voting rights acts and how they can help achieve the important goal of fair representation at the local level and have represented plaintiffs in federal VRA and state VRA litigation. We thank you, the legislators of Vermont, for taking on this important task in your state. By taking this pivotal step, you join the ranks of a host of states, including California, Washington, Oregon, Virginia, New York, Connecticut, Minnesota, and most recently Colorado, who have all enacted state VRAs. Other states, such as Alabama, Arizona, Florida, Illinois, Maryland, Michigan, Missouri, New Jersey, and Texas have made progress towards enacting similar legislation in recent years. The Election Law Clinic at Harvard Law School is one of many national groups joined by the NAACP Legal Defense Fund, Campaign Legal Center, Latino Justice, and Asian American Legal Defense and Education Fund that very recently drafted a model state voting rights act to provide guidance to legislators and organizers across the country as they seek to respond to shrinking federal protections for the right to vote. A state voting rights act at its core provides fundamental protections for voters that guard against discriminatory voting practices and policies. This model bill was designed to provide a consistent baseline and power-building tool for states to use. The Model Voting Rights Act is a template and highly flexible and adaptable. It's meant to be tailored to the individual needs of a state like Vermont. The model bill was developed through many years of work by our coalition of national voting rights organizations in speaking with lawmakers, community groups, and legal experts. It was recently made publicly available on January 23rd. I understand bill sponsors are considering raising amendments that would bring the Vermont VRA in alignment with the model state voting rights bill. I understand that the amendments do not change the intent of the original bill, but simply make it more effective in advancing Vermont voters' right to vote. These amendments are important to bring the Vermont Voting Rights Act into congruence with the Model State Voting Rights Act and strengthen and expand the scope of this legislation. The amended Vermont Voting Rights Act will offer 3 key protections. First, it will provide for coalition claims, including Middle Eastern and Northern African or MENA voters. This allows minority voters whose voting is aligned with another minority group to join together to create a claim for access to a voice in their local political system. Second, it will create a private right of action. This allows local voters to go first through a problem-solving notice letter process with the local election administrators to ameliorate voting access concerns before a last resort of litigation. And third, it ensures language access. The Vermont VRA requires that language assistance must be available for voters with limited English proficiency, so every eligible voter can participate effectively in democracy. Crucially, it centralizes those efforts in the Secretary of State's office, reducing the burden of this new policy on local election officials. State voting rights acts provide essential protections to promote fair participation and build a multiracial democracy that works for everyone, which is more critical now than ever. By enforcing comprehensive, clear standards, state voting rights acts prevent discrimination and expand opportunities to people disproportionately impacted by voter suppression and dilutive practices. I applaud the committee for taking up this important legislation for consideration and strongly urge the committee to adopt forthcoming amendments to bring the bill in line with the Model State Voting Rights Bill. As one of our coalition partners, Adam Liaz at the Legal Defense Fund recently said, state voting rights acts are a powerful, practical, and popular tool for protecting voting rights. The Vermont Voting Rights Act will make it easier to ensure that everyone has equal access to meaningful political participation at this crucial moment. We thank you for your leadership on this. Thank you, and I look forward to any questions.
Thanks a lot, Denise. We appreciate your taking time out. Not sure if it's any warmer where you are. It's pretty
No,
cold
she's
here
by
in
the
Vermont.
ocean. She's
Harvard, yes.
Harvard. She's warm.
We
Okay.
still have about 2 feet of snow on the ground, but
Yeah.
Oh, pointy. You have the ocean to keep it nice and warm.
Thank you, one and all. We appreciate it. I'm going to take a 5-minute break, and we have a final bill number S-291 to take up, and this was sponsored by, main sponsor Senator Vihovsky and Tim Devlin as the drafter. So when we come back, and please be as prompt as you can. As long as there's 3 people, we're gonna get through this.
Oh, we have 4.
Send you all home. Well, I
That's a
know,
lot.
but sometimes when we take a break,
Oh,
some people are
those
more
people.
punctual than others. So we will take a 5-minute break and be back in just a second.
Before
Nice to
we